So when you're looking at discrimination, there's 4 ways in which that can happen. Most obvious and easy to understand is direct discrimination. So it's very easy to understand that if you fail to give Mary a job because she's a woman, that's obviously direct sex discrimination. There's no justification to that unless we're talking about age. So it might be possible to justify retiring someone when they reach a certain age if you have an objective justification. So I'll talk about that when I talk about indirect discrimination. So indirect discrimination happens when an employer has a provision, criteria or practice, a PCP, which has the effect of putting a particular group of employees at a disadvantage because of their protected characteristic. So a classic example, you've got an employer who introduces a special bonus for employees who work during nights. Now that places women at a particular disadvantage because women mostly carry childcare responsibilities and are less able to work at night. So a claim was brought by a group of women for exactly this situation, but it involved the police. So whilst the starting position was that practice was indirectly discriminatory, the police said that we have an objective justification. Our aim in introducing this bonus is to reward police officers who work nights. So night work is particularly onerous and difficult, and it's also a particularly dangerous shift for police to work. So it's our aim to reward police who work nights. And it's proportionate offering a bonus. It was only a small bonus. It worked out to about £750 a year. And eventually the court agreed. So it went to EAT, and the EAT agreed, yes, that is a proportionate means of achieving the legitimate aim of rewarding night work. So although it was indirect discrimination, it was justified, and those claims failed. Harassment, I've put the definition up there of harassment. And what's really important to examine when you're looking at harassment is that it's conduct with the purpose or effect. So even if someone does something but they didn't mean it to have a certain effect, it might still be harassment. So your classic example might use what people describe as banter. Well, it's only banter, I don't mean to offend anyone, it's fine. It's not necessarily fine if it creates an intimidating or hostile workplace. And secondly, is the effect. So if it has the effect of creating that workplace, no matter other way around, if it doesn't have this, if no one is offended, but it was meant to offend people, that can still be harassment. So to give you a practical example, I worked somewhere many years ago, nothing to do with law. I worked somewhere where the office was predominantly women, and there was a workshop part of the business that was exclusively men that worked in the workshop. And the women in the office would frequently have to go into the workshop. And in the workshop, the men would every day put that day's page 3 up on the wall in a very obvious place because they thought it was very funny that women would come into the workshop and some would be embarrassed or whatever. They just thought it was very funny. And that is obviously sexual harassment. But the employer didn't really think there was anything wrong with that. So that would be a classic example of sexual harassment. I worked at another workplace actually, it was an insurance company, and they perhaps went to the other extreme. They did, senior management did a walkthrough, big open plan call centre type setup. They did a walkthrough one day, and one of my friends was very upset because he was forced after that visit to take down his Kylie calendar. Senior management said, no, that is sexual harassment and your female colleagues might be offended by Kylie's semi-clad body. She was very upset about that. Victimisation. So this is where an employee suffers a detriment, basically because of something related to the Equality Act. So there are four things. So they bring a claim under the Equality Act and they're then subjected to a detriment, or they assist someone else or give evidence or give information to do with an Equality Act claim. They do anything else to do with the Equality Act, or they complain of the employer breaching the Equality Act. The most common way in which victimisation happens is where an employee brings a grievance and they're complaining about something that's covered by the Equality Act, and then as a result of that grievance they are subjected to some kind of detriment. So I would say probably the most common way that we see this in employment is usually employees brought some kind of grievance that such and such manager is harassing them. There might be some sex discrimination or sexual harassment. Manager turns around and says, well, this person's underperforming, going to put them through a performance management process, or maybe a disciplinary processing. And that's generally how we see these kind of victimisation claims happening. You've got a couple of things that are particular to disability. So under all protected characteristics, non-disability claims will fall under one of those four categories, and then with disability you've got the special added elements of failure to make reasonable adjustments, which everyone's very familiar with, the duty to make reasonable adjustments for someone who's covered under who has a disability. And then discrimination arising from disability, which replaced an old concept of disability-related discrimination. And it can be difficult to pinpoint what that means and how it differs from indirect discrimination. But to give you a practical example, if you had an employee who was visually impaired and it meant that their output wasn't as good as another employee, but they were put through a performance management process and perhaps even dismissed, that could be discrimination arising from disability if you can justify the treatment.